I was standing at the end of my driveway in a bathrobe when she blocked the hazmat truck. Full Tyvek suits, court-authorized work order, two-person crew, and one woman with a clipboard and a visor that read, "Proper values matter," standing between them and my street, like she owned the Constitution. The crew chief leaned out the window.
Ma'am, we have a...
Not on my street.
She had zero legal authority, zero standing. What she had was 30 years of practice making this neighborhood afraid of her, and 8 months of filing complaint after complaint, trying to destroy my daughter's business. Every single complaint had come back clean, and she still wouldn't stop. I stood there watching her block that truck, and I thought about the document I'd filed with the state the previous Thursday. She has absolutely no idea. What would you do if someone came after your family like this and kept getting away with it? Drop your city below. Where are you watching from? Let me back up about 18 months, because none of this makes sense without a little context. My name is Dexter Calloway. I'm a retired railroad signal technician, 54 years old, and I bought my house on Briarwood Crest Lane in 2009, before the neighborhood even had a homeowners association. Back then it was just a row of modest split levels and ranch houses, carved out of red clay and Virginia pine. Neighbors waved at each other. People left zucchini on your porch in August without asking. It was, in the truest sense of the word, a neighborhood. Then, around 2014, a woman named Loretta Vance moved into the corner lot at the end of the cul-de-sac. I'll be careful how I describe Loretta, because honestly, words feel inadequate. She was the kind of person who saw community as a hierarchy and placed herself, without election or invitation, at the top of it. She volunteered to form the HOA. She drafted the bylaws. She appointed herself president. She printed business cards that said Community Standards Director, a title she invented, in an organization she invented, for a neighborhood that functioned perfectly well without either. For the first couple of years, it was small stuff. Loretta would slide notice cards under doors about grass height or the wrong color of mailbox post paint. Some people complied, some laughed. I kept a friendly distance and mostly ignored her, which she took as a personal insult. Then my daughter Tamsin moved back home. Tamsin is 26, a licensed HVAC technician, and when she came back she brought her rescue dog, a beat-up Chevy work van, and a small side business doing refrigeration system repairs out of my detached garage. She's a hard worker. The garage smells like refrigerant and machine oil, and there's occasionally a refrigerator unit sitting on the gravel pad beside it. Nothing noisy after 7 p.m., nothing leaking into the watershed. Just a young woman making an honest living. Loretta decided Tamsin was a blight. The first notice appeared on a Thursday. It was printed on official-looking HOA letterhead, which Loretta had custom-made, I kid you not, and cited a bylaw prohibiting commercial enterprise storage within residential curtilage. I'd never heard the word curtilage used by a non-lawyer in casual correspondence before. I should have taken it as a warning. We pushed back. I wrote a polite letter explaining that the garage was personal property, that Tamsin was a resident, and that no commercial signage existed on the premises. Loretta responded within 48 hours with a second notice, this one referencing a state code about accessory structure use that, when I looked it up, had been repealed in 2018. I should mention, the sound of Loretta's golf cart, she drove a golf cart, electric, which hummed like a wasp in a coffee can, became the sound of impending nonsense on our street. You'd hear that thin electric whine coming around the bend, and 4 out of 5 times, someone was about to get a clipboard in the face. Strike 3 came when Tamsin's work van needed a full refrigerant system flush. It's a legal procedure. It's a regulated procedure. Tamsin hired a properly licensed environmental services company to come out and do it. That company sent a 2-person crew in a white panel van with Precision Environmental Services printed on the door, and Loretta, who had apparently been watching our driveway like a hen watches a hawk, called the county to report an illegal chemical dumping operation. The county sent an inspector. The inspector looked at Tamsin's paperwork, EPA Section 608 certification, the whole stack, and left without writing a single citation. Loretta, in her parking lot general's mind, interpreted this as a battle, not a resolution. That was her first mistake. Her much bigger mistake was still 6 months away. The winter of that year was dry and cold. The kind of cold that creaks in the walls at night, and Loretta spent it sharpening her pencils. January brought a formal HOA violation assessment slid under our door. $150 fine for non-conforming accessory structure activity, a phrase Loretta had apparently workshopped because it appeared verbatim in 3 separate notices over 2 weeks. I'll note here that the HOA's governing documents, which I finally read cover to cover during a particularly dull weekend, contained exactly 0 mention of fines. The HOA had authority to recommend compliance. It had authority to request remediation. It had no authority whatsoever to levy monetary penalties without a formal member vote, a vote that had never happened. I didn't pay the fine. I also didn't say anything about why. That was intentional. See, I'm not a confrontational man by nature. 30 years on the railroad teaches you to be methodical. You don't touch a live wire because you're angry at it. You find the breaker. And before you find the breaker, you spend a lot of time understanding exactly how the current flows. So, while Loretta escalated, I documented. I started keeping a log. Date, time, description of every contact from the HOA or Loretta personally. I took photographs of every notice. I recorded the dates that she appeared outside our property, always within legal distance, always technically on the sidewalk or the street, but always there, golf cart humming, clipboard held like a scepter. The texture of those weeks was paper and patience. The waxy feel of printed notices, the faint chemical smell of the printer toner on HOA letterhead, the scratch of my pen in a spiral notebook I bought at the dollar store specifically for this purpose. In February, Loretta escalated to the neighbors. She convened what she called a community forum, held in her living room, invitation only, which meant she didn't invite me or Tamsin. I know what was said because our neighbor Wendell Birch, who is 71 years old and has absolutely 0 patience for being managed, attended and then texted me a bullet point summary from his driveway while Loretta was still pouring lemonade. The summary: Loretta had told the assembled neighbors that my garage was a chemical storage facility, operating without permits, that Tamsin was exposing the neighborhood to toxic runoff, and, this is where it gets creative, that her presence was depressing property values. I want to be precise about what Loretta was doing here, because it matters legally later. She wasn't just gossiping. She was making specific, factual claims. Chemical exposure, permit violations, property value impact, to a group of homeowners who shared a common interest in those claims. That is what's known as defamation by implication. I wrote it down. The next week, Loretta filed a formal complaint with Hanover County Zoning and Code Enforcement Office. I found out about it when a county officer named Deputy Supervisor Marsh called me to schedule an inspection. He was professional. He was also, I could tell from the way he spoke about the complaint, mildly annoyed to be dealing with it. Marsh came out on a Tuesday. He walked the property. He examined the garage. He reviewed Tamsin's documentation. He found a storage cabinet with clearly labeled refrigerant cylinders, all sealed, all properly logged under EPA requirements, all within legal residential limits. He told me, standing in my gravel driveway with the winter bare trees throwing blue shadows across the ground, that he found no violations. He also told me, off the record, that the complaint had been filed using language that was unusually specific for a civilian. His words. Someone, he suggested, had done some research before filing, which meant Loretta wasn't just being impulsive, she was being calculated. Here's the thing about calculated bullies. They're used to winning because most people don't fight back the same way. They're used to opponents who get emotional, who yell, who threaten and fume and then exhaust themselves. They are not used to opponents who smile, say, "Thank you for your time," and go inside to update their notebook. I updated my notebook. I also, for the first time, called a lawyer. Not to sue anyone, just to understand the landscape. The lawyer I spoke to, a real estate and HOA specialist named Gaines Rucker, who charged a flat $200 for an initial consultation and was worth every cent, told me 3 things that changed how I thought about the whole situation. First, the HOA's fine authority was, as I suspected, almost certainly unenforceable. Second, there were specific Virginia statutes governing HOA conduct, including provisions against selective enforcement, treating similar properties differently based on personal animus. Third, he said, almost as a throwaway, You said she has a lot of old equipment in that corner lot, right? Have you ever looked at what's actually in her yard? I had not. I made a note. Spring came in loud that year. Mockingbirds at 4 in the morning, the smell of turned earth and Bradford pear blossoms that somehow always smell like something that died. And with spring, Loretta's campaign against us entered a new phase. She began, in March, to formally catalog every vehicle movement associated with Tamsin's work. She had apparently purchased a small trail camera, the kind deer hunters use, and mounted it on a post at the corner of her lot, angled directly down Briarwood Crest Lane toward our driveway. She made no attempt to hide this. The camera was in a standard orange and black housing, zip-tied to the post, blinking its little red light. I looked up Virginia law on surveillance cameras in residential areas. It's legal in Virginia to record from your own property anything visible from a public vantage point. Her camera was pointed at a public road. Technically, she was within her rights. So, I bought a trail camera of my own. Mine faced her lot. Not provocatively, not vindictively, because Gaines Rucker's throwaway comment had lodged itself in my head like a splinter, and I had started to pay attention to what Loretta actually kept on her property. The corner lot at Briarwood Crest was generous, about 1/3 of an acre, partially fenced in the back with a wooden privacy screen that had grayed and warped over the winters. Inside that fence, visible from certain angles on the public road, was a collection of items that deserved a second look. There was a rusted chest freezer, door removed, lying on its side in the back corner. There was a cluster of old propane tanks, at least 6 of them, varying sizes, some with rust blooms on the collar. There was what appeared to be an old above-ground oil storage tank, maybe 250-gallon capacity, sitting on cinder blocks near the fence line. Virginia DEQ regulations are specific about residential fuel oil storage. Tanks over 1,100 gallons trigger commercial regulations, but tanks of any size require proper secondary containment if located within certain distances of drainage features. Loretta's lot had a drainage swale running along its southern edge. I photographed all of this, calmly, legally, from the public road. The click of a camera shutter is a quiet sound, but it was the loudest thing I'd done in this whole saga. Meanwhile, Loretta's escalation continued on the HOA front. In April, she convened an official HOA meeting, this time with proper written notice to all members, because apparently someone had reminded her that the bylaws required it, and put a motion on the floor to formally censure my property for ongoing commercial use violations. The meeting was held in the community gazebo, a sad little octagonal structure that the neighborhood had installed in 2017, and that was now mostly used for HOA meetings and one very ambitious family's annual garage sale. I attended. Loretta had not expected this. When I walked through the gazebo entrance, the look on her face, a micro-expression of genuine alarm, quickly smoothed over into professional ice, was worth every morning of patient documentation. I waited until she finished her prepared remarks, which included a color-printed handout she had clearly spent real time on. Then I raised my hand. I asked 2 questions. First, could she direct me to the specific bylaw provision authorizing the HOA to levy monetary fines, along with a record of the member vote required to activate that provision? She could not. Second, had the HOA applied similar scrutiny to all residential properties on the street regarding accessory structure use and outdoor equipment storage? Silence. 3 of the neighbors shifted in their folding chairs. Wendell Birch, bless his heart, made a sound that, in a different setting, would have been called a chuckle. Loretta tabled the motion, pending legal review, which meant she had nothing. But I could see in the tight line of her jaw that this wasn't over. She wasn't the kind of person who accepted a stalemate. She was the kind of person who regrouped and came back with a bigger weapon. The weapon she chose, it turned out, was the county environmental complaint system. In May, she filed a second complaint, this one not with zoning, but directly with the Virginia Department of Environmental Quality, alleging that Tamsin's refrigerant work constituted unauthorized hazardous material handling and created potential groundwater contamination. The DEQ investigation would require Tamsin to produce all her certifications, logs, and disposal records for an official review. It was a significant paperwork burden, even when you're fully compliant. Loretta knew that. That was the point. Tamsin spent 3 nights at the kitchen table going through paperwork. The kitchen smelled like coffee and the particular stressed human smell of fluorescent midnight work sessions. She produced the binder 2 inches thick. The DEQ cleared her completely. And while they were on site, I made a phone call. Polite, factual, professional, asking whether, while the inspector was in the area, they might want to take a look at an adjacent property with an aging fuel oil tank sitting next to a drainage feature. The inspector made a note. By June, Loretta had apparently decided that the regulatory route wasn't delivering the knockout blow she needed, so she pivoted to something older and meaner: social pressure. She began, systematically, to work the street. Every few days, the golf cart would hum from house to house. Loretta would spend 10 or 15 minutes at various driveways. I could see her from my garage window, clipboard present as always, gesticulating, pointing toward our property. I couldn't hear the conversations, but I could read the body language of some of my neighbors, the polite nods, the crossed arms, the gradual step backward toward the front door that meant, "Please, I have things to do." Most of my neighbors are decent people. A few of them were genuinely uncertain. Was there something to Loretta's claims? Was Tamsin's operation actually a risk? People hear hazardous materials, and their brains fill in gaps. That's human. That's also why Loretta used the phrase every time. But here's what Loretta didn't understand about the street she'd been trying to govern for a decade. Most of us had been here longer than her, and most of us had memories. Wendell Birch remembered when Loretta had tried to get his son's basketball hoop removed because it was inconsistent with community aesthetics. His son was 9 at the time. The Kowalczyk family at number 14 remembered when Loretta had filed a noise complaint against their daughter's violin practice. The girl was 12 and practicing 30 minutes a day. Patricia Osei, who lived directly across from me, had her vegetable garden cited as a visual nuisance in 2019. None of these people had forgotten. And when I started knocking on doors, quietly, without a clipboard, with a 6-pack of Cokes and a copy of the actual HOA bylaws, they started talking. I wasn't building a mob, I was building a record. I asked each neighbor to write down their specific experience with HOA enforcement. When it happened, what was cited, what outcome occurred. I explained what I was doing in plain language. I was documenting a pattern of selective and punitive enforcement that, under Virginia HOA law, constituted abuse of fiduciary duty by an officer. 11 out of 14 households on Briarwood Crest gave me written statements. 11. I kept those statements in a manila folder labeled, with perhaps excessive tidiness, HOA Conduct Record, Resident Testimony. The folder lived in a fireproof box in my closet, next to my tax returns and Tamsin's EPA certifications. Now, while I was assembling this quietly and methodically, Loretta had found a new card to play. She had apparently consulted someone, a friend, a cousin, someone with a passing familiarity with municipal codes, who told her about a county ordinance governing commercial vehicle parking in residential zones. Tamsin's work van, which was parked in our driveway, had her business name and license number on the door panel. Under a certain reading of the ordinance, this could constitute commercial vehicle storage. Loretta filed the complaint on a Thursday in late June. The compliance officer who responded, a young woman named Specialist Hadley, who had the manner of someone who had seen absolutely everything, came out the following Tuesday. She measured the van. She reviewed the ordinance. She explained to me, in a voice of absolute bureaucratic neutrality, that the van qualified as a personal use vehicle primarily garaged at the operator's residence, which was exempt from the commercial vehicle ordinance. Then she asked, without any apparent irony, whether there was anything else I wanted to discuss while she was here. I handed her a copy of my trail camera photographs, the ones of the propane tanks. Specialist Hadley looked at them. She looked at the address on the filing paperwork in her hand. The complainant's address. She looked at the photographs again. Something shifted in her expression. Not unprofessional, not dramatic, just the slight recalibration of a person who has just understood something. She said she would forward the photographs to the appropriate department. The appropriate department, it turned out, was the county's fire marshal office, which has jurisdiction over residential propane storage in quantities exceeding certain thresholds. 6 propane tanks of mixed size, stored unsecured on a residential lot without a variance? That was not nothing. The fire marshal's office opened an inquiry. Loretta didn't know that yet. She found out roughly 3 weeks later, when a vehicle with Hanover County Fire Marshal on the door pulled up to her corner lot on a Wednesday afternoon. The sound of that truck's engine cutting out in front of her house, a heavy diesel idol dropping to silence, was, by all accounts from neighbors who witnessed it, absolutely beautiful. She was cited for improper storage, but even that wasn't the main event. The main event started with a routine request I'd almost forgotten about. Back in April, while I was doing my quiet research phase, I had submitted a public records request to Hanover County for the full property file on Loretta's corner lot. All permits, all inspections, all code correspondence. Virginia's Freedom of Information Act is genuinely useful. Most municipalities have to respond within 5 working days, and the requests are free for small volumes of records. I noted this in my log as a standard due diligence move. Then I mostly forgot about it while the spring's various skirmishes played out. The response arrived in late June, in a Brown County envelope. 41 pages. I sat at my kitchen table on a Sunday morning, coffee going cold beside me, and read every page. Most of it was unremarkable. Property transfer history. A 2009 deck permit, properly closed. A 2015 fence permit. Then, on page 31, I found something that changed everything. The corner lot had, in 1987, been home to a small engine repair shop. Before the subdivisions, before the HOA, before any of the houses on Briarwood Crest Lane were built. The shop had operated for 9 years, until it was closed in 1996, and when it closed, it had been subject to a county environmental review that resulted in a conditional property release, meaning the property was released for residential use, conditional on the previous owner completing soil remediation for petroleum hydrocarbon contamination. There was a remediation certificate on file, signed in 1998 by a company that, when I Googled it, had gone out of business in 2003 and had, in the intervening years, been the subject of state enforcement actions for fraudulent remediation documentation. In plain language, the contamination remediation on Loretta's lot had been certified by a company later found to be falsifying cleanup records, which meant the actual remediation status of the soil on that property was, at minimum, unverified. I sat with that for a long moment. The coffee had gone fully cold. A cardinal landed on the garage windowsill, looked at me with its little black eye, and flew away. I thought about what this meant. Loretta had purchased that property in 2014. Did she know? Maybe. Maybe not. That wasn't my department. What was my department was understanding whether this fact was actionable, whether an unverified remediation on a residential lot, combined with an aging fuel oil tank sitting near a drainage feature, constituted an environmental concern that could be formally raised. I called Gaines Rucker. He listened to the whole story. There was a long pause. Then he said, "You know there's a mechanism under Virginia Code for a private citizen to formally request that a property be assessed for environmental hazard designation, right? It goes through DEQ. If they substantiate it, the property can be restricted from certain uses until the situation is resolved. A hazard zone designation, not criminal, not punitive, just regulatory. The property wouldn't be condemned. That's a misconception people have. It would simply be subject to restrictions on use and transfer while the environmental question was properly investigated. It also, Rucker noted, had implications for the HOA. Because Loretta had been operating as the HOA's president and using HOA authority, such as it was, to pursue enforcement actions against my property. If her own property was simultaneously under an environmental inquiry she had arguably known about, that was what lawyers call a conflict of interest so egregious it borders on comedy. I asked Rucker to draft the formal request. He said he'd have it ready by Thursday. The next 6 weeks were the calmest of the entire affair, at least on the surface. Loretta continued her campaign. The golf cart continued its rounds. Notices continued to appear. I continued to smile politely, document everything, and say nothing substantive. But underneath that quiet, a great deal was being assembled. Rucker's filing to DEQ, a formal citizen request for environmental assessment under Virginia Code Section 10.1-1186, went in on a Friday. This is a real mechanism. Any Virginia resident can file one. You submit it with supporting documentation. In our case, the property records showing the conditional release, the information about the remediation company's subsequent enforcement history, and the photographs of the fuel oil tank near the drainage swale. DEQ is required to acknowledge the request and assign it for review. The review can take months, but the clock starts running the moment you file. One quiet legal move. No press release. No confrontation. Just a form, filled out correctly, submitted to the right agency. Meanwhile, I had been consulting with a second attorney, this one a specialist in HOA law named Fletcher Drummond, who practiced out of Richmond and had a way of explaining legal mechanisms in terms so clear they felt like common sense. Drummond's focus was on the HOA's fine structure. He prepared a formal written challenge to every fine that had been levied against my property, totaling, by this point, $975, citing the absence of a valid member vote, the HOA's own governing documents, and the Virginia Property Owners Association Act, which contains specific provisions about when and how HOAs can levy fines, and the due process homeowners are owed before any fine becomes collectible. Under the Act, a homeowner who receives an improper fine can demand a hearing before an impartial board. The HOA has to respond within a specific time frame or the fine is voided. Drummond sent the challenge letter via certified mail, which I found satisfying in the precise, tactile way of doing something correctly. The heft of the envelope, the peel and stick certified mail sticker, the receipt the post office hands back to you. Here's the practical takeaway, because I know some of you are sitting there thinking about your own HOA situation. If your HOA is levying fines, the first thing you do is request the governing documents and look for the member vote that authorized the fine structure. No vote, no fine. That's the law in most states, and a certified letter challenging the authority is cheap insurance. At the same time, I was working on the community side. I mentioned the 11 neighbor statements I'd collected. What I hadn't mentioned yet was what I was doing with them. Patricia Osei, who turned out to have a paralegal background from a previous career, had offered to help me organize and present the testimony in a format that could be submitted to the HOA's own governance process. Specifically, a formal motion to call a special member meeting and place on the agenda 1. A vote of no confidence in the current HOA president. 2. A review and ratification of the existing fine structure. 3. An amendment to the bylaws adding an anti-retaliation provision. Under Virginia HOA law, if a certain percentage of the membership requests a special meeting in writing, the board is required to schedule it. The threshold varies by governing document. Ours required 25%. We had 11 of 14 households. That's 78%. The petition went out in mid-July. I walked it from door to door on a Saturday morning, clipboard in hand for the first time in this entire story, in the particular thick heat of a Virginia July that makes the air feel like warm, wet cloth. Every household I'd spoken with signed. A couple I hadn't even approached added their names when they heard what it was for. 14 days later, Loretta was legally required to schedule a special member meeting. She scheduled it for the third Saturday in August, the maximum delay the bylaws allowed. I suspect she was hoping to use the intervening weeks to marshal some kind of defense, or perhaps to find a reason to delay further. What she didn't know was that the DEQ had, by this time, formally acknowledged the citizen assessment request and assigned it to a field investigator. She also didn't know that the fire marshal's propane citation had been referred to a county compliance officer for follow-up. She also didn't know that Drummond's fine challenge letter had a response deadline of August 5th, and that if the HOA didn't respond, the fines were voided by operation of law. And she absolutely did not know that one of Tamsen's professional contacts, a licensed environmental contractor named Beaumont Ellis, had offered, as a professional courtesy, to walk the DEQ investigator through exactly what a proper refrigerant handling facility looks like, versus a property with a leaking 40-year-old underground fuel oil contaminant and 6 unsecured propane cylinders 30 feet from a drainage swale. All the pieces were in place. All we had to do was wait. Loretta spent August panicking. I know this because Wendell told me, because Patricia told me, and because the golf cart was running more miles per day than a UPS truck in December. She had, by the second week of August, apparently figured out that something was happening. Not the full picture. She didn't know about the DEQ filing yet, but the certified mail from Drummond's office had rattled her. She called an emergency board meeting, which was just herself and the 2 other HOA board members she'd appointed, a retired accountant named Roy, who mostly just wanted to be left alone, and a woman named Geraldine, who had seemed to genuinely believe Loretta's claims about Tamsin until Patricia sat down with her over coffee and walked her through the actual documentation. Geraldine, to her enormous credit, resigned from the board on the spot. That left Loretta and Roy, which was barely quorum, and Roy had started wearing the expression of a man who deeply regretted volunteering for anything. The August escalation took 3 forms. The first was a smear campaign, conducted mostly through the neighborhood's private Facebook group, a place I'd never engaged with, which in retrospect was a small mistake because I hadn't been tracking what was said there. Loretta began posting long entries about community safety concerns and professional obligations to neighbors and residents who are unresponsive to legitimate remediation requests. She never named me directly. She didn't have to. On a 14-house street, the geometry was obvious. Patricia, who was in the group, screenshotted every post. The second form was a direct approach to the county. Loretta, presumably acting on whatever research she or her consultant had done, tried to file a preemptive complaint with the county about Tamsin's operation. A third round through the same regulatory machine that had already cleared us twice. The county's environmental compliance office had, by this point, a thick file on our address. They also had my trail camera photographs, which I had formally submitted as part of a complaint regarding Loretta's propane storage. The inspector who reviewed the new complaint called me as a courtesy to let me know they'd reviewed it and were, gently, closing it without action. He also told me, less gently, that the DEQ field investigator had visited Loretta's property the previous week. The third form of escalation was the strangest and, in retrospect, most revealing. In the 3rd week of August, Loretta approached Tamsin directly, in our driveway, on a Tuesday afternoon while I was out. I know this because Tamsin told me about it that evening while we were eating dinner, and the flatness in her voice suggested she had been turning it over all day. Loretta had offered, Tamsin said, to make the whole thing go away if Tamsin would cease operating her business from our address, and, this was the part that made the food in my mouth taste like something off, if she would encourage her father to withdraw whatever complaints he has filed with the county, Loretta would rescind all the fines, drop the HOA complaints, and let things return to normal. That is a settlement offer, made without an attorney, in a context where a formal legal challenge to the HOA's authority was already pending. Fletcher Drummond, when I called him the next morning, used the word extraordinary with the controlled enthusiasm of a man who has just been handed an unexpected gift. He documented it. He also sent a follow-up certified letter to the HOA, informing them that any further direct contact with me or my family members regarding the pending legal matter should be directed to his office. Loretta's response to being told to stop communicating directly was to send a typed letter, actual physical mail, which felt almost nostalgic, informing me that she intended to pursue all available legal remedies against my property and my daughter's business. It was the kind of letter that is meant to intimidate. It's written in that formal register bluster that sounds serious if you've never dealt with an attorney's actual correspondence. I read it, added it to the folder, and did something that felt almost cruel in its ordinariness. I called Rucker and Drummond, updated them, and went to bed at 10. Meanwhile, the DEQ field report was making its way through the review process. The fire marshal compliance follow-up was scheduled for the 1st week of September. The special HOA member meeting was set for August 19th. Everything was converging. I slept fine. The week before the August 19th meeting, Loretta made her final play, and I have to give her some credit, in the reluctant way you give credit to someone who has correctly identified their most dangerous vulnerability and tried to neutralize it. She went after the quorum. She began making personal visits, not golf cart drive-bys, but actual front porch conversations, to as many of the 11 signatory households as she could reach. I know the content of several of these conversations because the neighbors told me. The strategy was the same at each stop. Not aggression, not the clipboard and bylaw approach, but something softer and more insidious. I care about this neighborhood. I've given years to this community. I know there are some frustrations, but do we really want to blow everything up over one dispute? Dexter's daughter brings chemical trucks into the neighborhood. Don't you want that looked into? It was the voice of someone who knows the vote is coming and is trying to peel away just enough support to make the special meeting fall below quorum. 25% of 14 households is less than 4 households. If she could get enough people to simply not show up, the meeting couldn't proceed. She almost succeeded with 2 families. I say almost because Patricia Osei, who has a master's degree in public health and an absolute intolerance for manipulation dressed as concern, made 2 phone calls on the Friday before the meeting, and both families confirmed they'd be there. The Saturday of the meeting was one of those dense, overcast August days in Virginia, where the air smells like coming rain and the cicadas sound like they're arguing. The meeting was held in the gazebo, same as always. 14 households were entitled to attend. 13 showed up. The one absent household had a family emergency. Their daughter was in the hospital and had submitted a written proxy. Loretta arrived 5 minutes late, which I had not expected. She was dressed in a blazer over her HOA polo, which I also had not expected, and she was carrying a thick folder of her own. She had, it seemed, retained someone in the interim. Not a full attorney, I learned later, but a paralegal who did HOA governance consulting. The blazer made sense. She sat at the head of the folding table and arranged her papers with the deliberate movements of a person performing calm. I sat at the far end. Tamsin was to my right. Fletcher Drummond, who I had invited to attend as my representative, which was my right under the Virginia POA Act, was to my left with a leather-bound legal portfolio. The sight of him seemed to land on Loretta like a physical weight. She looked at him. She looked at me. She straightened her papers again. The meeting was called to order by Geraldine, who had agreed, despite her resignation from the board, to serve as parliamentarian for the meeting, on the grounds that there was nobody more familiar with the HOA's procedures who wasn't a party to the dispute. She had the calm authority of a retired middle school principal, which she was. Nobody argued with her. First item, election of a meeting chair. The membership voted. Loretta nominated herself, 3 hands. I nominated Wendell Birch, 10 hands. Wendell accepted with visible reluctance and the grace of a man who had been waiting a long time to be useful. Loretta's folder was already open. She began, without being recognized, to speak about the ongoing environmental concerns regarding my property. Wendell said, with extraordinary politeness, "Loretta, you'll have an opportunity to address those in the discussion period. We're working through the agenda." She sat back. The formal challenge to the fine structure came first. Drummond presented a 4-page summary of the issues: the absence of a member vote authorizing fines, the specific violations of the POA Act, the cumulative amount levied without legal authority. 3 of the neighboring households who had received their own fines in prior years realized, for the first time, that those fines had been equally invalid. The gasps were small, but genuine. The vote to void all outstanding fines and require future fine authority to be established by formal member vote. 12 in favor, 1 against, Loretta. 1 abstention, Roy, who looked like a man counting the days until his term expired. Second item, the no confidence motion. And this is where the meeting was interrupted, by a hazmat truck. I want to be precise. I had not planned this. I had known the DEQ had been in contact with the county regarding Loretta's property. I had known the follow-up was coming sometime in September. I had not known it was coming on August 19th. I had not known that the preliminary DEQ findings had been significant enough to trigger the county to issue a formal notice of environmental concern and schedule a site assessment with a Precision Environmental Services crew. The same company, same white van, same 2-person crew in Tyvek suits that Loretta had called the police on 14 months earlier. They pulled up to the corner lot at the end of Briarwood Crest Lane at 2:17 in the afternoon, while 14 homeowners and 1 HOA president sat 60 feet away in a gazebo. The timing was, as I said, not something I had arranged. Some things just have a sense of occasion. You could hear the diesel engine from the gazebo. That deep, unhurried idle of a commercial environmental services vehicle is a distinctive sound, low and authoritative, the kind of engine note that means this visit is not optional. Several heads turned. Someone in the back said, "What is that?" in the tone of a person who suspects they are about to witness something significant. Loretta turned last. She turned slowly, the way people turn when they already suspect what they're going to see. And when she saw the Precision Environmental Services van idling at her curb, with its two-person crew in Tyvek suits climbing out and pulling equipment from the rear cargo doors. The color in her face went through approximately 3 distinct phases in about 4 seconds. I watched it happen. I imagine I will remember it for a long time. Wendell, to his everlasting credit, simply continued the meeting. "Second item on the agenda," he said, in the voice of a man who has seen everything in 71 years and is not about to be derailed, "is the motion of no confidence in the current HOA president." Loretta pushed back her chair. I need to go." She stood, gathering her folder. "This meeting is... There's an issue with my property." "Loretta." Drummond's voice was measured and even. "The meeting is in session. You're entitled to speak in your own defense on the motion. If you leave, the vote proceeds without you." She looked at him. She looked at the van. She looked at the 13 neighbors watching her. One of those neighbors, Patricia Osei, had her phone out and was quietly recording the proceedings, which was legal and which Loretta clearly knew. She sat back down. Here is what was happening at her property while she sat. The DEQ's preliminary assessment, based on the records I had submitted and the field investigator's initial site visit, had identified 2 primary concerns: the proximity of the uncontained fuel oil tank to the drainage swale, and the unresolved status of the 1998 remediation certification from the now discredited company. Under Virginia DEQ protocols, when a site has an unverified remediation and an active potential contamination pathway, a formal site assessment can be ordered, and during that assessment, the property owner receives a notice of environmental concern, which is a public record attached to the property title. The Precision Environmental crew was there to conduct the formal site assessment and deliver the notice. In practical terms, the notice doesn't mean the property is condemned. It doesn't mean the owner is being prosecuted. What it does mean is that the property cannot be transferred, refinanced, or used as collateral for any loan until the environmental status is formally resolved. A process that, depending on what the soil test showed, could take months or years. The notice of environmental concern is, in the language of real estate, about as welcome as a lien. Back in the gazebo, Wendell called the no confidence vote. In favor, 11. Against, 1. Loretta, who voted for herself with the mechanical precision of a person doing the one thing left available to them. Abstaining, Roy, who put down his pen with a small, definitive click and stared at the folding table. 11 out of 12 voting members, an overwhelming removal. Loretta said, in a voice that had lost its professional register and become something smaller and more human, "This isn't legal. You can't just vote me out." Drummond slid a 1-page document across the table. Section 7.4 of the governing documents, which you authored, provides for removal of an officer by majority-member vote at a duly noticed special meeting. This meeting satisfies all required conditions. She looked at the paper. She looked at the van, which was now fully deployed at her property line, with a second county vehicle, a DEQ-marked SUV, having arrived behind it. The DEQ field officer and one of the Tyvek crew were walking the perimeter of her lot with a clipboard. A clipboard. The irony was rich enough to bottle. "I'd like to say something," Loretta said. The room waited. Something had shifted in her. The blazer and the performance were gone, and what was underneath was just a tired woman who had miscalculated badly. "I was trying to protect this neighborhood." "From what, Loretta?" Wendell asked. She didn't answer. Patricia Osei, with the patience of someone who has prepared for this moment, set a laminated sheet on the table, a summary of every HOA enforcement action over the past 8 years, cross-referenced by property, showing clearly that the overwhelming majority of actions had been directed at 4 households, all of which shared a common characteristic. They had, at various points, challenged Loretta's authority. No one said anything. No one needed to. The special meeting concluded 17 minutes later. Wendell was elected interim HOA president by acclamation. Roy, who visibly relaxed upon the conclusion of his involuntary board service, seconded every motion with the gratitude of a man being released from something. Outside, the Precision Environmental crew worked methodically through the golden August afternoon, sampling, documenting, doing exactly what they were there to do. The aftermath moved at the pace of bureaucracies and paperwork, which is to say, slowly, but completely. The The DEQ site assessment confirmed that there was residual petroleum hydrocarbon contamination in the soil on Loretta's corner lot. Modest in scope, not catastrophic, but real. The fuel oil tank was removed under a compliance order in September. The contamination was addressed through a legitimate remediation process, this time by a licensed contractor with a clean regulatory record. The notice of environmental concern remained attached to the property title until the remediation was complete and independently verified, which took just over 7 months. During that period, Loretta was unable to refinance her home, which she had apparently been planning to do. I did not feel good about that in the way one might expect. The outcome wasn't designed to hurt her financially. It was a consequence of a situation she had created and maintained, and had arguably known about, while using HOA authority to attack a neighbor's livelihood. The HOA fines were voided in their entirety. Drummond sent a formal notice to that effect. I chose not to pursue recovery of the time and legal fees I had incurred, partly because I didn't need the money badly enough to spend more of Tamsin's evenings in court prep, and partly because the resolution itself had been sufficient. Tamsin's business, for the record, is doing well. She added a second van in the spring. She now employs 2 part-time technicians, both of them women, both of them recently certified. She keeps her paperwork immaculate, out of habit and, I suspect, a certain grim amusement. The HOA, under Wendell's presidency, was restructured modestly but meaningfully. The bylaws were amended to require member votes for fines, to add a formal grievance process with an independent review panel, and to include an anti-retaliation clause. The camera Loretta had mounted at the end of the street was quietly removed. Nobody asked the new board to take it down. It just wasn't there one morning. Now, a few things worth understanding if you're dealing with your own situation. The DEQ Citizen Assessment Request is a real tool. Virginia Code Section 10.1-1186. Other states have equivalent mechanisms. If you have a genuine environmental concern about a neighboring property, not as a weapon, but as a legitimate worry, it is your right to file it. The Virginia Property Owners Association Act, and most states' equivalent HOA legislation, contains specific procedural requirements for fines. If your HOA is levying fines without following those requirements, a certified letter from an HOA attorney can void them and stop the clock. The consultation alone is usually less than $300, and public records requests, FOIA requests at the county level, are free, are usually answered within days, and contain information most people never think to look for. Property files, permit histories, prior compliance actions. The story of almost every piece of land is in those 40 or 80 or 200 pages, if you ask for them. As for the neighborhood, Briarwood Crest Lane is quieter now. Not in the suffocated way it was when the golf cart made its rounds, but in the genuine way of a place where people have stopped being afraid of their neighbor. Patricia Osei started a community garden in the common area near the gazebo. It produces tomatoes, collards, and squash in quantities that regularly exceed what anyone can use, which means bags of vegetables appear on porches in August again. The smell of cut tomato vine on a hot afternoon is one of the better smells in the world. It's the smell of things going as they should. The Birch family's grandson, Wendell's grandkid, 8 years old, has a basketball hoop at the end of their driveway. Nobody says anything about it. And next spring, there's talk of a block festival. A small thing, nothing elaborate, with a scholarship fund attached for kids on the street who are pursuing trade certifications. Tamsin's idea. The kind of thing that starts with a conversation in a driveway and ends, if you're lucky, as a tradition. This story is done, but yours might be just starting. If you've survived an HOA nightmare, tell us in the comments. Every story deserves to be heard. And if you know someone living under a Loretta, share this video. It might be the most useful thing they see today. Subscribe. The next one is already in progress, and trust me, you want to be here for it.